Welcome to the COVID updates. Let's give it a few minutes to allow people to join, and then we will get started on some very important topics today. I hope everyone is doing well, and I hope social distancing, but still managing to be social. And we'll give it just a second, and then we'll get going. Thank you for joining us on our weekly COVID updates. If you have been joining us every week, then thank you for your continued support. And if you are a new attendee, well, I hope you find this informative and helpful. That is the primary goal of what we're trying to do. So without any further ado, we will get started. So one thing I've enjoyed about, during this COVID process is I've, given the fact that everyone is so worried about immigration, I've really enjoyed connecting with people, trying to help them through this process. As I've said many times before, my family's gone through it, I've gone through it, and so it is more than just paperwork to me. It is what I've committed my career to, and it's something I am both passionate about and purposeful about. And that's what they say you need to have for your career: passion and purpose. So connect with us on any of these different mechanisms. We use each mechanism slightly differently to communicate the latest changes and what's happening with immigration, which is like something different every day, right? I mean, it's like a whirlwind. So this is a way you can get different types of information, some more detailed, some, we're sending out just to send out quickly on all those platforms. And we'd be happy to, like I said, connect with you. If you've missed some of our YouTube videos, please, check them out on YouTube. We've gone through everything from very specific things about H-1B RFEs to how to really draft a perm petition so that that it can be most successful for you. So, we've done the whole gamut of different types of ways in which we can connect. So check out the YouTube video, comment on it. I'd love to hear your suggestions. We're doing this, I'm doing this for you. So if there's something you like or something that you think we could do better, we'd love to hear from you, because we want to improve and make sure that we are focused on giving you the assistance that you need. Subscribe, and please share it with your friends, because the more we're able to get the information out, the more we're able to impact and help people. We got an email just yesterday from one of the attendees of the seminar where we gave them some strategies on how they could approach a specific issue, and they emailed us back to say that they were very successful. So, that makes us very happy. And that's the primary purpose of all of this. So today we're going to go through, because I belong to a couple of forums, and with the questions that we've been getting, I think there's still a great deal of confusion on Dropbox versus emergency appointment. There are two criteria for both of those. And a lot of times I see questions, well, are we scheduling an emergency appointment through Dropbox? Well, no, because if you're doing Dropbox, you wouldn't need it. So we're going to go through the mechanics of that and some success stories of why emergency appointments are granted and what evidence do you need. Now, and I'll go through what I've reviewed. We've had someone just secure a successful emergency appointment 2 days ago. And it was the documents that we prepared that really was the secret sauce in that. We're going to go over some October visa bulletin, highly awaited. up till 11:20 today, I checked to see if it was published, and it still wasn't. I don't know if it's going to be published while we're recording this webinar, but we're going to tell you what our thoughts are on the various issues. And then we're going to go over things that you haven't even heard in the news. We keep track of what the USCIS, they have to, because they're an administrative agency, they have to do some reporting, which used to be easy. You would get the email easily if there was a change that was anticipated or taking place. Now they've made that harder, but we figured out how to get the information. So we've got a couple of those under the radar immigration changes to go over with you. But first, I'd like to take a second because as we are doing this right now, the memorial for the Supreme Court Justice Ruth Bader Ginsburg is happening right now in Washington. The notorious RBG. Her father came to the United States when he was 13, and her mother was a daughter of immigrants. She, for anyone in the legal field, especially women, but for everyone, she was really a leader at a time where it was very difficult for women to excel in the legal field. I mean, that's been the case all along, but especially at her time. And she really heralded cases about equal justice, not just for women, although it propelled women, but she's also represented a number of men where she thought the treatment was disparate. So I thought it would be appropriate just to take a moment to honor the great work that she's done and recognize it as we move forward. So on with our webinar. Okay, Dropbox versus emergency appointment. Now, Dropbox basically means that they are waiving your interview. You don't have to do an interview. And it's only available for certain types of visas and in certain circumstances. So the Dropbox is the waiver. The expedited or emergency appointment is when you need to have an interview, right? So there's a difference. One is without an interview, and one is where you're saying there is an emergent or expedited reason why I need an interview date, an in-person interview. And that's why, like I said, when I keep seeing these questions on the forums that say, hey, how do we apply for a Dropbox expedited appointment? Well, that they're kind of in contradiction to each other, because if you're applying for Dropbox, then you don't need an interview. And who qualifies for the Dropbox? Well, you have to apply for the same visa classification you currently have or currently had. And it used to be, it had to be expired within the past 12 months. They have increased it to 24 months. And then it has to have been issued in the same country. We put that in as a clarification from last week, when previously they weren't so particular about that, but it is something that they look for now. So same visa, same country of issuance, 24 months. You haven't had any visa refusals, and no arrests, no convictions, no B1, B2 overstays, and the visa could not have been previously lost. You still have to be in possession of it to be able to present it. And the Dropbox eligibility is if you've received your visa after 2008, January 1st, you're 18 years or older. There was no annotation in your previous visa, and F1s can get one if they're continuing students, J1s, if it's issued at the same institution as the previous, like, for example, if you're working for CDC as a J researcher, then it would have to be issued for the CDC again in order, in order for it to be issued. So this is all about a Dropbox. This is all pertaining to, I am waived from having to undertake the interview. Now, if you don't meet that criteria, that means you've applied, but you've got a 221G on your previous visa for employer A, and you're now with employer B. Well, you haven't secured a visa. So the visa would have to have been stamped, same classification, same country, and the window of expiration is 24 months. So that's what the Dropbox eligibility is. Now, if you're not eligible for that, and given that there are no appointments available for 2020, you'd have to file for an emergency appointment at the consulate. And they use emergency and expedite kind of interchangeably, you know, so sometimes you hear of emergency and expedite, but in their requirements, they're basically the same. So they're almost interchangeable. So the reason they've got very clear mechanisms for outlining what is eligible for emergency travel: medical needs, funeral needs, urgent business, and students. So you'd have to fall into one of the criteria. And what's critical is the evidence that you would need, and I'll talk about that in just a second. So how do you schedule the appointment? You do it like you normally do. You can request the earliest appointment depending upon, I think, the different, if you're different consulates in different countries, have different appointment availability. And then, you print the confirmation and you have to complete the expedited form request. So you have to note why it's an expedite or an emergency appointment. And then you can supplement it. There's a mechanism with evidence that you have, which is really critical. So that's how the process is for getting the appointment. You can only schedule an emergency appointment one time. If you're refused, you have to wait for the next available appointment. So that's why evidence that you submit is really important. Now, it could be that you filed and you didn't notate that it was a emergency appointment. You thought you did, but we had someone that said that they submitted a letter asking for a waiver. So that means you haven't requested the emergency appointment yet. So you still have the opportunity to do so. There are national interest exceptions. And we featured that, I think, in our previous platform, where there are reasons why individuals may be exempt because their work is in the national interest. And so take a look at our last week's YouTube video, because we outline what that is very specifically, and the fields and all the things that you would need to know about the national interest waiver exception to the process. So there is remember, there's a Dropbox, there is the emergency or expedite request, and there is the national interest waiver. So those are the three parameters. A lot of people question if they've received a 221G, what can they do now? Can they request an emergency appointment at this point? Now, 221G just means that with the documents and information that was initially submitted, that, typically it may have gone into administrative processing at one point, and then it moves to 221G refusal. So 221G refusal just means that the evidence wasn't sufficient. There's additional evidence that's needed. And I see that there's some questions, but I want to go through this, and that way we've finished off one section and I can answer all those questions, in the context of what we've gone over. So, one of the things was, well, we didn't have sufficient evidence. You didn't submit X, Y, and Z when you filed. You may be able to, refile again with some additional information, but it's not always the case. But if you have additional information and that was the basis of your 221G refusal, you could do it. And if you qualify for the emergency or expedite, you may be able to get an expedited appointment to address your 221G, because right now, they are processing immigrant petitions that were issued at 221G as of September 1st, but there's no real notification that they're doing that for the non-immigrant petitions. But there is a mechanism within the regulations that allow that. So you may be able to leverage that. And like I said, it's a case-by-case basis. So it's not one shoe fits all. So let me answer some questions while we just finished topic 1. I see there's some on chat and there is a question on Q&A. What if my request for a visitor visa got denied? So are you asking whether you can apply again, or does this impact your Dropbox eligibility? Remember that one of the is Dropbox only available in India for H-1B, or do you have can you do Dropbox in Canada if you are an Indian citizen and your previous H-1B was stamped or done in Canada? Emergency request for a visitor visa. Well, you can't, if your visa got denied, if it was denied based on 221G, you may be able to get an emergency request for a visitor visa if you meet the criteria. So you'd have to check to see if that is available. Third country processing for Dropbox is kind of sketch, but I think I may have a mechanism where, I understand that in Mexico, things are a lot more liberal in the way in which they process. So you may be able to get a stamping done there. So Sandeep, I'll send you some information on that, both about the Dropbox and about the stamping, because in some countries it specifically says that this is your home country and you can only Dropbox if this is your home country and your previous visa was issued here. That's not so for all, but it's for most. And since Canada has typically been, Canada and Mexico, typically been the exception for third country processing, I would rather check before I let you know what that is. Let's look at yes, if you all could ask the questions on the Q&A versus the chat, that would be great, because that way we'll be able to preserve the questions. Okay. And okay, the October visa bulletin, I'm glad you asked that. We are going to address that in just a second. The question is, I am in India and I have a valid H-1B valid for 2 more months. Now, if I file an extension and it's approved, will I be able to use the Dropbox? I got the last one from the same consulate. I mean, the current restrictions on the new visa do not apply for Dropbox. Correct. So you could either, if you file for an extension and you do premium, and your visa is still valid, you don't need a valid visa to stay in the United States. You only need a valid visa to enter. So if your visa is still valid and you can show at the port of entry that you've got an approval for your extension, then you should be able to enter based on that. So you wouldn't even need to go through the Dropbox if your visa is still valid. Even if you change employers, if you have an H-1B visa, it still would be valid for travel. So the great thing is you've got a valid travel document that would exempt you from all the restrictions, and then you wouldn't really have to go through the Dropbox issue. Do the J and J2 have to complete the 2-year physical presence separately, or if a J1 completes it, the J2, no. If the J2 is going to join you, then it needs to be completed. If the J2 is not going to join you, it just depends on, you know, how you're going to change it. And the other thing is, if you're eligible, if you're on a J and you're eligible for an O, you don't have to worry about completing your 2-year home residency. You can enter on an O. O is one of the exceptions to the 2-year home residency. So you have to process that at the consulate. You can't change your status in the US on an O. But if you still have a 212E restriction, then you would be able to, enter on the O. And then as you keep going back and forth, you can add to that completing your 2-year home residency. So that's a great prospect. Next question is, hello, currently I'm in India and my new employer is saying if the client provides a critical resource letter, only then can we schedule an appointment for an H-1B change of employer. If I can't apply for an H-1B, what other visas I can go given that I have an I-140 approval? Okay, that's not true. If your employer can demonstrate that there is a critical need, based on the type of work that you're doing, and he can show a redacted contract that, okay, for example, let's say you're an architect doing critical work for Anthem, right? Maybe you're working on a project to make sure that the billing system or some system is more streamlined. Well, you are providing and your role on that is critical. Your employer can demonstrate that, and he can provide the letter, and he can provide, details about what the project is. And sure, it would be great if in that example, if Anthem could support that, but I'm sure that there is project details and other details that they can provide that would, further establish your ability. And one of the things I may have just flown over this without going into it in greater detail. For the expedited appointments, the evidence that you need is you need to demonstrate, especially if you're basing it on a business need. Remember, there's certain criteria. We went over them last week. Critical infrastructure, your role is critical. There's going to be a tremendous business loss if you don't go. Well, what I would tell you is that what you need to demonstrate is that specifically what is it that you're working on? Not general, but specific details. Number 2, see if you can have the employer kind of monetize the loss. If they can monetize the loss and they can say, well, this is a critical resource and we've got 10 other US citizens that are being supported by this person's work and their job is also at stake. You can make a really strong, compelling economic argument. And that's what we did recently in the one that we were able to secure. And in that instance, it was for an H-4. So we had to show that the H-1B who had a visa had a critical role. So he had to return to the United States. And then we showed that he had some compromised health issues that would mandate that his H-4 spouse travel with him back to the US. And so it was a 2-pronged test, but we got a doctor's letter. We had details about the illness. We had some reports that we were able to readily find by reliable sources. And then we had the employer kind of detail what exactly the role was and what the loss would be. And I'm telling you, that's the secret sauce. It's the specificity and the details. To get a successful, okay, so I just answered, the question was to get a successful expedited appointment on a business emergency, what documents should be submitted? So I just answered that. A letter from your employer, make sure if there is any evidence, if it's not a big name employer, there's something that they have, like project documentation, you know, communications with the end client, if there's somebody else that's involved, to detail what it is you're exactly doing. Because it can't be just that you're working on this important project. It's not enough they say it. They have to outline what that is and why your role is critical. And then they need to say, we will lose X amount of money. This is how much is at loss. And the icing on that cake is that you are supporting additional US workers. And if you're not allowed to be in the United States, those US worker jobs may be jeopardized. Next question. Hi, Lakshmi, I got my H-1B stamped under NIE. Do I need to carry any special documents while traveling from company or client to show work at the POE? You mean at the port of entry? So the question is, a person got their H-1B stamped and they want to know if they need to carry any special documents to show at the port of entry. Well, it's always good to have your documents, but if you've got the visa stamp and you've got all your, you know, in case they ask, and that usually comes up, like, for example, if you're traveling to the US and your job is in Washington, DC, for example, but you've got family in California. So you thought, okay, let me go see my family in California before I fly to Washington. Well, that's going to raise some questions in their mind because you're flying into a port of entry that's not where your work location is. So in that instance, you want to be able to have documentation to show that, you know, what your project is, where you're going, and that there is availability of work. So take the documents you submitted to the consulate, take any current employer letter confirming employment, and any documents relating to the work that you'll be doing, just to present it in case they ask. When will the USCIS publish the new I-129 and I-765 forms? Well, the new fees and forms are supposed to be effective October 3rd. There have been times where they haven't published it in the time frame specified, but that is what is anticipated. I came to the US with an L1. After 2.5 years, I applied for permanent residency. So far, fingerprinting is done, but I'm waiting for the actual card. As 3 years on my original L1 is expiring October 15th, we applied for an L1 extension, which was returned to an RFE. Do you feel like this will affect my GC process? Well, once you filed the adjustment, so you're both on an L1 and you're an adjustee, you're holding both those statuses at one time. And you can do that because L1 and H1 have dual intent. So you can intend to stay here temporarily and you can intend to stay here permanently, which is great. So if for some reason your L1 is denied, then you still have your adjustment. And so once you have work authorization, you'd be able to work pursuant to your adjustment. But if until you get that work authorization document, you can't. The great thing is with an L extension is you can continue working for 265 days while it's pending. We've been very successful with L1s. Knock on wood, no denials this year. And our L1 specialist, John Milburn, is spectacular when it comes to addressing L1s. And there is a surge in issuance of RFEs, and that has something to do with some resource issues that they're having that I'll be talking about in just a minute. I'm going to answer 2 more questions and get to the next topic, and then I'll come back and answer some more. The next question is, I was under the impression that the new H-1 visas are being used in emergency cases if we can't provide an emergency case, but we are eligible for Dropbox. Can we get a fresh H-1B visa? Remember, Dropbox is not for fresh H-1B visas. Remember that in order to be eligible for Dropbox, you would have had to hold that visa previously, and you have a 24-month window in which that visa would have expired previously, and it's being issued in the same country. So the ban is on processing of new H-1s, but there's certain H-1s that are not subject to the ban because they expanded it and clarified it. And if you look at our YouTube video from last week, we actually go through that step by step to see how you may be eligible, even though it's a fresh H-1B for a visa. So there's the eligibility of the visa, and then there's securing a visa appointment, right? So then if you are eligible and you want an appointment, then you would file for an expedite or emergency appointment if you meet the criteria outlined. So there's kind of a two-step analysis to that. First, you have to be one that is not subject to the ban. And then secondly, you have to be eligible for the emergency appointment. Now, I see that we've got 7 other questions, and I promise I will answer them, but I want to get through some of this PowerPoint first. Okay, visa bulletin predictions. This is the most awaited visa bulletin in the history of all visa bulletins. And we have, like I said, been checking usually on the 14th or 15th of every month. The visa bulletin for the next month gets published. Till now, the new visa bulletin hasn't, and I think it's because they know that there's going to be a substantial number of visas available. It is predicted that there can be 250,000 employment-based visas available. A 63% increase, and that is the biggest number by far ever. So with that, there is some concern about the ability for the USCIS to even handle this. And the reason why there's a surge is because remember, a number of the family-based petitions could not be filed because of the early ban and the COVID and everything else. And then there's been a backlog of visa allocations from China. So all of this is contributing to the boost for the visas. So if, so as we outline here, it's calculated by the supply. And so there's 140,000 that's allocated per year. It's 7% per country. And so it's a very strange way in which they calculate. Family members count against that. So because there was a drop in family-based, you know, if it's not used, it can be then allocated to the employment-based. So that's what is going to be, you know, what's going to happen. And so if you think that this may be, that you may be helped, I can't predict how much the 250,000 would help, you know, India boost, but it's going to advance pretty substantially. So if you're outside the United States, you have to consular process, but there are some restrictions on that, so that may be problematic. But if you're in the US, you can adjust status. And so connect with us on social media, because as soon as the visa bulletin is announced, we're going to put it on blast. And like I said, we've been checking it like crazy, you know, to see when that's going to come out. And then you can start getting all your documentation ready. So if you've got an I-140 that's approved, and you want to start gathering all your documents in terms of birth certificate, marriage certificate, if you got family members, you know, all the other information that you can. And remember that the visa bulletin, if it's current for October, everyone's going to file. So what's going to happen in November? It's going to retrogress. It's going to go back. So you have that 1 month window in which to file. That's why I have been preaching from the beginning of COVID, get your permanent residence started, get your permanent residence started. And I said, because if there is a window that opens up, if you don't have an approved perm, because if certain numbers are current for India, we don't know to what extent, but you know, you won't be able to file unless you know you have that I-140. I mean, you have that perm approved, and if it's not current, but there is a, you know, the dates have been promoted tremendously, then you would have had to have an I-140 approved. But you can also think about if the dates are current for like EB2, national interest waiver, whether you know, which doesn't require having a perm in place. Not everyone's going to be eligible for national interest waiver, but that is certainly something to truly think about if the numbers become current. Because even if they retrogress, the great thing is you'll be getting work authorization and advanced parole through your adjustment application. You don't have to, we always suggest it's great to have an underlying H or L or other classification, but this is pretty big in that you can keep on extending your employment authorization through this process. So these are what we tell you to do. And one of the things we want you to remember, because a number of you won't be filing through us, we know this, you want to make sure that your attorney knows this, that all 485 filings after February 24th, 2020 must include an I-944, which is the new public charge document. Now, RFEs are going to be issued for all cases that were filed prior to October 13th that didn't have the I-944. That's a pretty long, complicated document. And it really requires a lot of time to prepare. After October 13th, the I-485 will be rejected without the I-944. So remember, it's really important when you have that 1 month window, right? You have a 1 month window to file your adjustment, that your attorney include the I-944 if they're filing after October 13th, because you don't want it rejected. Because if it's rejected, by the time it gets back to you and then you're able to refile, October may be over and the numbers may retrogress and you would have missed that opportunity where you would have been able to file. Before I get to immigration changes in the news, we have 11 questions. So let's go back to answering some of those questions. Can I apply for a visitor visa if I have an I-140 approved? Probably you can apply, but the likelihood of your being able to secure a visa is going to be difficult. And I'll tell you why. Unlike the H-1B and the L, remember I said those are dual intent. You can intend to come to the United States temporarily and you can intend to come to the United States permanently. The visitor visa, the F-1 visa, the J-1 visa, you have to demonstrate that you intend to return to your home country. So if you can show that, you know, and it would depend on what the visa bulletin is. Let's say, because if the visa bulletin is current, they're certainly not going to let you come in on a visitor visa. But if it's not current for your I-140, you would have to show that, yes, I do have an approved I-140, but I'm only going in for 4 weeks. And here's my return ticket. Here's the reason why I have to go. It's going to be a higher threshold in which you have to overcome. because it's hard when you've got an approved I-140 petition and you've got, that's one of the questions on the DS-160 form that, you're going to return to your home country unless it is an application for an H or L visa. Next question is, my priority date is October 2010. Oh, I'm so sorry you've been waiting for such a long time. Eagerly waiting for the, the reason why it's taking so long this month. The question is, I'm eagerly waiting for the October visa bulletin. Any idea why it's taking so long for the visa bulletin to be released? Because of the jump in numbers. The USCIS is probably scared out of its wits how it's going to handle all these applications. And I'll tell you why in a second. It's even more so. But that's the reason why. Hi, team. Any insight you have on the visa bulletin is delayed for October and the date it may be released? It may be any day now. And like I said, the reason for the delay is specifically because of the jump in numbers. They are freaked out. And so that's the reason why. And here is another question on the visa bulletin. When is it going to be released and what kind of movement for EB2 India is expected? I think there's going to be, it's hard to say because it's hard to know how many people that were in the backlog previously through other retrogression, how many family members they had. So it's all based on family members, and that would predict, how much of it can be utilized. But like I said, if it is current for you, you've got the entire month of October. At October 14th or 15th, you can look to see what's going to happen in November. And I'm pretty sure in November, there's going to be a retrogression. I have my first H1 stamped and it got expired March 2020. And I'm currently on an H1B. My H1B is transferred to a new employer. If I travel to India, would I be eligible for a drop box? Or do I need an emergency appointment to show that I'm a critical resource? Well, if your H1 was originally issued in India and you're still filing for an H1 with your new employer, and none of the other things in the drop box, like for example, there's no criminal record, you haven't been refused, all those things, as long as they don't apply, then yes, you're eligible for drop box. You don't need an emergency appointment because you're asking for an extension of a previously issued visa at the same country, and the expiration of that previously issued visa was less than 24 months. Another question is, my H-1B extension was recently with 2B checked. Can I apply EA or do I need to submit documents from the employer? Well, it's not enough that you say that there is an emergent need, you have to be able to demonstrate it. And you do that through letters, you do that through supporting documents. So that's the biggest, for the people that have gotten their emergency appointment denied, that's been the biggest reason. It's because they didn't provide, the letters that they provided were very general in nature. He's a critical person. It's really important that they come. We'll lose a lot of money. But that's not specific enough. That's general. Anyone can say that. What you have to do is say, this is the project we're working on. Detail it. This person is a critical resource on that project. Why? Answer the question, why is he a critical resource? Then finally, what is the company going to lose if this critical resource is not there? And as I stated earlier, the two most compelling things is the financial loss, and then if you can point to how this critical resource supports other US workers, that's fantastic. And you should be able to, but you have to be able to support that with some evidence. So how do you show that it's a critical resource? Project documents, emails by the employer, any type of information related to the project will help you further support the letter that the employer will write. Next question, based on the visa bulletin, do we expect EB1C to become current? Last, it was 2008. That's what they are. That is one thing that they had predicted a couple of months ago. So we do expect EB1C to be current in October. Yay, fingers crossed. Next question. Hi, Lakshmi, I'm trying to get admission in master's here in the US. So it is a real matter between term course computer science or information systems technology. From the immigration perspective, as both courses, I believe, follow STEM. So I guess the question is, I'm looking at a master's degree program in the US. One of the programs is in computer science, and the other one is information technologies. Are these both STEM degrees? Yes. But it's a good question because there's some degrees that you would think are STEM, because STEM stands for science, technology, something in mathematics. I forgot what the E stands for. Engineering and mathematics. So you would think that, like for example, a dentist has to take a lot of science classes and math classes. So, but the dental program is not considered a STEM program. So it is good question that you brought up, and you can't automatically assume that what is intuitive for most of us is intuitive for the USCIS. And there is a list online where you can look up what the USCIS STEM classifications are for any of you that are, if you've got friends that couldn't attend today and anyone else that's looking at what STEM, what the STEM fields are, you can look it up on the USCIS site. Next question, if I am in India and the I-140 is approved, my priority date is 2015. With the consulate closed, how will I apply? That's the rub. That's going to be a problem for you to be able to apply in the consulate. And by the time the ban is addressed and you are able to secure an appointment, it may retrogress. So it's really an exciting thing for the Visa Bulletin for this to take place for the people who are already here. If you have an I-140 approved, try to get back into the country before October in some capacity, in the legal capacities that I've outlined earlier. That's what's really important, because if you can get back here, you can file an adjustment. That should give you even more of an incentive. And the best way to get back here is through an H or an L, because you got an I-140 approved. And so it would be critical that, they probably wouldn't approve a visitor visa for you in that sense. Next question is, if I have an I-140 approved with the old employer, will that still be applicable if the window's open? Without the I-140 being transferred. So the question is, this individual has an I-140 approved by his previous employer, and he has not yet filed an I-140 with his new employer. He wants to know if the I-140 is still valid for purposes of filing for an adjustment. Well, if your previous employer did not revoke your I-140, and there is still a promise of employment working for that employer, even if it's not current, if it's future, then yes, you can file for the I-45 with the previous employer, but you can't do that without the consent and without the offer of prospective employment with that employer. Next question. My earlier question had a typo, so they're writing it again. So am I eligible for Dropbox in a traditional sense, as my last H-1B expired within a year and I was issued in the same country? What I wanted to know is, Is the consulate in India still processing visas via Dropbox despite the ban on the new visas? Remember, the ban on the new visas has been relaxed a little bit. So look at our previous YouTube video. We go through it to go through that relaxed stance on H-1B visas in great detail. So number one, if you do come under the relaxed restrictions, then yes, you can file for a Dropbox, but you have to first make sure you're not subject to the ban. Step number one is making sure you're not subject to the ban. Step number two is then understanding, are you eligible for Dropbox or do you schedule an emergency appointment? But you have to first make the analysis of whether you're subject to the ban or not. So please look at last week's YouTube video on the Cello Law YouTube channel. And that should, and if you have any questions afterwards, email us at info@cellolaw.com and we're happy to answer. But I'd love for you to take a look at the video because it does go into it in great detail. Next question. Maybe the question is unrelated for the current presentation, but if you can give your responses, that will be great. I am an F1 student working on campus, was asked to discontinue work during COVID. Aren't these students eligible for weekly unemployment since March? The next question is EB1 green card. Does it have to be on the basis of the PhD completion, or even while the PhD is about to finish, one can apply? Is there a way to expedite the application through an extra fee? Specifically, if the spouse is from a country eligible for diversity lottery program. Okay, that's a lot to unveil. So first, the F1, you'd have to see what your state unemployment regulations are, because you can only work on campus for 20 hours a week. There's some states that require anyone getting an unemployment benefit to be full-time, so you'd have to check your state unemployment regulations to see, and you said Ohio, and to see what applies there. Second question, you can absolutely file the EB1 without completing your PhD, as long as you are eligible for the EB1. So we had gone over the EB1 criteria in one of our previous webinars, but if you would like the checklist, we'd be happy to send it to you. And I've been reviewing resumes of people to assess whether they're eligible for the EB1 or not. EB1 is most likely going to be current in October. So if you file through premium processing, which you can for extraordinary ability, you can't for EB1C, which is multinational manager. You can't for national interest waiver, but you can apply for premium processing for extraordinary ability. But if you apply for premium processing, you can't file your adjustment with the premium filing. Okay, so here's a tip from me to you. If you are going to file for EB1 under extraordinary ability, because October, the numbers show that it is current, don't file premium processing. You want to file concurrently with your adjustment because the numbers may retrogress. So you file your I-140 for your EB1 and you file your I-485 at the same time. Okay? I hope that makes sense. So that's one thing a lot of people don't realize with the downfall of filing for an expedite on the EB1C is that you can't file you can't file a concurrent adjustment filing with that. So you've got to look at things a bit strategically to see what works for you. When is the visa bulletin going to come out? We are checking, as I stated earlier. And if you follow us on social media, you will be the first to know. Next question. Hi, thanks for taking my question. Do you think the USCIS will never use the left FBGCs from leftover from last year? Well, they are first, I guess Okay, family-based, that's exactly what they're doing. The October 1st is the new fiscal year for the USCIS. So they are taking the allocations that were unused because of the marriage-based cases, and they're going to be using them this year. Next question. Can I use the previous employer I-140 for filing the I-45 with the current employer? No, you cannot. The I-140, an approved I-140 from your previous employer gives you, confers on you the priority date. So that's vested with you. It gives you the ability to extend your H-1B beyond the 3 years. What it does not do is it does not allow you to file the I-45 unless you're going to join your previous employer, and they would be willing, you know, with their consent for prospective employment. So you can't do it with your current employer, but if the previous employer has not revoked it, you would be able to utilize the previous I-140 for that employer. My I-140 is approved through the last employer, but my current I-140 is in progress. In case the status is current, how does that affect me? Great question. Great question. You've got a previously approved I-140 with employer A. That priority date vests with you, okay? You've got the I-140 in process with employer B. If that priority date is current in October, you can file an I-485 to be attached to your I-140 that's currently pending. You see what I'm saying? You can file the I-485 to the I-140 that's currently pending, leverage your previous approval priority date. So it wouldn't be, you wouldn't look at the priority date for your current one that's in process. You'd look at the previous one and assess by the visa bulletin whether you are current. If you are current, then you can file your adjustment, attaching that adjustment to your pending I-140. Yay, good luck. When is the EB3 expected to be current? You know, if I could predict that, I wouldn't need to be practicing law. I'd be making a lot of money just on visa bulletin predictions. What is the expectation for the EB2 India moving forward for October? Again, we can't predict it. 250,000 is pretty substantial, but we'll have to kind of wait and see. Can you please post a link to last week's video? You were talking about, I cannot find it. Yes, and if you look, if you go to YouTube and look for Challa Law offices, and I think you have to go to our COVID weekly updates. And I think Kara will post a link on chat or something now, then you should be able to file it. But we'd be happy to send that to you. And if you still can't find it, send us an email at info@challalaw.com. There we go. In chat, Kara has posted where the last week's video is, so you should be able to access it. Did you already cover the October visa bulletin? Sorry, I just joined. What we did say was it's going to be a big jump, 250,000 we expect to be allocated. We don't know when that's going to, how that's going to affect the current backlog, but we suspect it's going to be substantial. And, but we're waiting for the visa bulletin to be issued. They are delaying it because there's going to be a big jump and there's going to be a lot of adjustment filings that are going to be filed in the month of October. Thank you for taking time to answer all our questions. Can't thank you enough. You made my day. Thank you. And if you really like this, do you mind sending us an email telling us that you do like it? And if you're okay with we're trying to gather some references from people who have listened to the webinar and send it out on our social media if you don't mind, just so that people know. I mean, we work hard to put this webinar together every week, and I really strive not to give you just general answers and things you can Google. I want to help you. And so if you could, like I said, email us at info@challalaw.com, info@challalaw, and tell us if you've enjoyed this, and give us the permission to post on social media. I'd really appreciate it. I really would. Thank you. When EB3 is expected to be current? Oh my God, don't know, but we're looking for the October visa bulletin. EB1C can be filed. This next question is, EB1C cannot be filed concurrently, correct? That is incorrect. EB1C, which is multinational manager, employment-based first preference, cannot be premium processed. Can't be premium processed. But if the date is current, you can file your adjustment. You can attach your adjustment to your pending I-140 EB1C application. So you can file it. That's why I said it's exciting. If it becomes current next month, you will be able to file it with your the I-140 that's currently pending. Yay! And so even if it retrogresses, you can get employment authorization, travel, so you're not totally dependent on your H or L. Unrelated to this presentation, next question, but many employers ask the question, how long will we need to retain all the original notices from the USCIS after getting the citizenship? You know, I would digitally hold on to them. You never know down the road. The Trump administration has this, you know, revoke citizenship task force, which is something that's never happened in the history of the United States. So you don't know what they will do. I don't think you need to keep the originals, but I would keep, because, you know, they can verify the originals through their system, but I would at least keep a digital copy of all your documents for safety purposes, because you don't know what crazy is going to come out of the USCIS in the next, if the administration doesn't change. Any insights on getting a visa stamp for those in India and qualify for the NIE? I'm still waiting for the F2 interview to happen to get my stamp. So if you are eligible for an F2, remember that's the first thing we have to see. Are you eligible for the visa? Is there anything about the ban or restrictions, like for example, that your F1 spouse is taking in-person study, or they're hybrid, then I think you would be eligible for the they would be eligible for the F1, and then you could get the F2 if you qualify to obtain an emergency appointment. So I know that they are trying to expedite it for F1 students, but if you can show that there's a reason as an F2 spouse that you should be expedited, then I think you would be eligible. And we covered that earlier as to what qualifies for an expedite. If your I-1 priority date is January 2011 and approved with the previous employer, with the new employer, no I-140 is started yet. If the October 2020 bulletin, even though my 2011 priority date is eligible, will I miss the opportunity for the adjustment of status? Only if you are willing to work for your previous employer. If you're willing, if the previous employer has not revoked your I-140 and you're willing to go back and work for that employer, and it doesn't have to be currently, it can be prospectively, then you're eligible to file the adjustment of status for that. Remember, if you're overseas, it would be problematic. But if you're in the United States, you will be able to file for the adjustment. Thank you so much for your efforts in hosting these sessions. Are very helpful. Well, you're welcome. And again, if you like it, please email us and give us permission to be able to promote it. I mean, it's a difference when, or comment on our YouTube videos. It's different when I say people have been saying that it's helpful, because that's really the objective that I have, that we have. It's a team that puts this together, that we have in putting the weekly webinars, but it is something totally different when it comes from you. Okay, my gosh. Okay, we've got 8 more questions and we've got some things to cover and it's already 1 o'clock. If the dates advance forward for October visa bulletin, many people can file for adjustment of status. In what orders are the OS applications processed? The order of the priority date or the AOS application received by the USCIS? Well, let me tell you a couple of things about that in just a second. H-1B transfer was approved for April 2020 for consular processing. Can I go get stamping as Dropbox in London as I've stamped earlier in the same location? Can you try? Yes, if you are eligible, remember, you have to make sure you're not subject to the ban because you have a transfer. And if you're not subject to the ban, look at our previous YouTube video, it outlines that. And since your transfer was approved for consular processing, you can, if your previous visa was issued in London and it was issued within 24 months, you should be able to do the Dropbox. My spouse is currently missing the I-797. Do we need an I-797 to file AOS if it becomes current? Yes, and see if you can do a FOIA request. Try looking online, putting it in online, but you can do a FOIA request. If you don't have a particular document when you're filing for your adjustment, here's another tip. File it without it. There are certain things that you must have, like your I-140 approval notice to show that you are eligible. But birth certificate, you know, some I-797s are not there, you know, a number of other things. The key is you want to get it filed by October, within the month of October, and then start working on trying to get those documents. So when and if an RFE is issued, you'll be able to supply it. But don't wait to get the document and miss the date, is what I'm trying to tell you. Sorry, I meant H-1B visa for a face-to-face interview. I'm sorry, Dave Ram. I forgot what your original question was because I've gone through so many. So for the face-to-face interviews, for those who have to have an interview, if you are eligible for the H-1B visa or L-1B visa, whatever it is, then you have to see whether you qualify for the emergency or expedite. That's going to be the one that's face-to-face. Thank you for resuming the webinars. You are welcome. And like I said, give us some love on info@cellolaw.com. We really appreciate it. You know, share it, share our next webinar on your social media, social platform, so you can let people know that it's informative, so we can try to spread the word and help people as much as we can. Hi, Lakshmi. John is waiting for December 2020 to file. For December 21st, 2020 to file the I-140 for me. It'll make it 2 years that we've been doing business for 18 months. Shall we go ahead and file anyway? Wait, you shouldn't go ahead and file anyway. You should wait, but maybe we can explore to see if national interest waiver or EB1, you may be eligible for either of those. So if we're worried that we'll lose the window, explore different options. Because if EB2 is valid, then national interest waiver is where you can file, which doesn't require the perm process. And, you know, one of the reasons is, you know, innovation in business. So, you know, that may be a perspective that we look at, an option as we move forward. Okay, Mr. Jeet Singh, I am an Indian citizen. I have a BB1 approved, but I received a 221G on my O1. Can I travel to the US on a tourist, change my status back to O1 when it gets approved? It's going to be, if they know that you've got an EB1 approved, I don't I think you're gonna have a problem getting your tourist visa. And if you file for an adjustment, so when you travel to the US on a visitor visa, whether it's B1 or B2, for 60 days after you enter, you can't file anything, cannot file anything. You certainly can't file an adjustment of status. So, that would be an issue. I would think EB1s, hopefully they will hold for some time. If you got a 221G, find out what additional documents you need that you could submit and reapply, and maybe get an emergency appointment to get it approved. We do a lot of EB1s and O1s. We were the Attorney General for the state of Virginia, even under Ken Cuccinelli, for about 10 years, until we were going to merge with another firm and we were conflicted out. But, there may be, if it's a 221G for an O1, which is rare, there may be additional documents that you could submit and then qualify for an emergency if you're working in a critical area where we can get you back in on the O1. So email us at info@cellolaw.com so we can take a look at it more specifically. This is very helpful. Thank you for doing this call. I recently switched jobs. My perm is in process, hasn't started yet, and I've approved I-140 for the previous employer. If the PD becomes current, what are my options? Only to work with the previous employer, because, or unless you qualify for a national interest waiver. So if your perm hasn't even been started yet, the prevailing wage documentation takes some time. And if you have been listening to my webinars since March, I think the one thing I've been saying is get your permanent residence started, get it started. Because if a window opens up, it's going to be a small window for you to be able to file. So you can go back and work for your old employer if he hasn't revoked it, and if there is a promise of prospective employment. So hopefully that'll happen. Let me quickly run through these. The biometrics rule, previously, remember, it was just for certain individuals like H4s, or now they're going to expand the biometrics, use it as identity verification. And we don't know what else they're going to use it for. So they've expanded the definition. So it's not just going to be the fingerprinting, the photo. It can be anything from retina to whatever other ways in which you can biometric someone. So, and it allows for DNA testing for establishing genetic relationships. And it's also expanded so that it is used for US citizens. So if you're filing for your parents, family-based petition as a US citizen, previously the US citizens weren't required to get fingerprinted or go through the biometrics. So now they're expanding it. So even the US citizens they'll be eligible for biometrics. This is going through notice and comment. We'll have to see. I think there is going to be a challenge on privacy issues. I don't think the USCIS can fingerprint US citizens, but we'll have to see. So the furloughs, we've been talking about the furloughs forever. So even though they've held on to their main employees, what's happened is their contractors have been let off. And so a contracting company that's been supporting the USCIS announced 800 to 1,000 furloughs. So this can mean further delays in processing. Yay. And then, of course, they have formalized the citizenship of military members that are born abroad, mandating the requirement that the US citizen have legal and physical custody, which sometimes is not the case, because if they're stationed abroad and their spouse is in the US with the children, they may not have physical custody. And physical custody can mean Legal custody is one thing, but physical custody, you know, if you're dispatched abroad, you may not be there. So it would really limit the ability for individuals to get that benefit. So this is a reminder that USCIS fees and forms are going to change on October 20th. N400s are going to increase by 83%. I-129s are going to split by case types, and premium processing will be calculated by business days, not regular days. It's going to be a 15-day business day calculation. And remember, the I-944 for any I-45 that's filed. We've got a new chat room. I had joined a number of chat rooms, but they would not let me give folks any answers on the chat rooms. And so I think I've been kicked off a number of them as well. So I wanted a place where people could go chat, and, you know, there'd be resources that we would submit, you know, whenever there's a change, and so folks can get real answers. Most of the chat rooms are put together to secure some type of financial benefit for the person who's administrating the chat room. That's why they don't want answers to come out free, because they want to offer things like, oh, here's $30, you can consult with an attorney, or you know, so there can be some money making component to it. Ours is not a money making component. And, you know, throughout this process, people have been telling me, hey, you've given, you know, there's been clarity. I've gotten clarity from you. So our tagline is clarity for hum. It's forum, but actually for hum, for all of us. Hum meaning us. So this is a place in which you can, and we'll start expanding it to other immigration classifications as well. But this is a place that you can ask your questions, and that we'll be issuing answers. And so please join us. Like I said, I'd love to chat with you. So I'd love for you to join our forum and connect with us on social media. Like I said, that's how we're going to get out our information on the much awaited October Visa Bulletin. So very excited about that. And if you like our YouTube videos, comment, share, like, and if you found these webinars helpful, please email us. And if you've got topics you want me to cover, you know, this is for you. I'm doing this for you. So this is 1 hour where you get me for free. And, you know, I will answer all your questions. And just so I'm sure a lot of you know this, some of you don't, for the most part, when you're consulting with an attorney, they charge a consultation fee. So my consultation fee was $250 an hour. Well, $250, it wouldn't even be an hour. Most of the time it'd be half an hour. And for the most part, I have been answering questions and trying to make myself available, you know, foregoing that, the fees that we were getting from those consults, because I really want to help folks during this critical time. So I hope you found it useful and helpful. You can view our recordings at Cella Law. I think Kara shared a link on chat so you can find it. And you know, email us at info@cellalaw.com with any additional questions. And you know, I look forward to, where is this? Okay. I look forward to, I'm trying to stop share. I look forward to speaking to you next week, next Wednesday at 12 p.m. Eastern Standard Time. And God knows what the topics are going to be, because every day there's a new change. So, you know, look out for our emails where we will tell you what topics we're going to cover, and stay tuned on social media. October Visa Bulletin. So exciting. Take care. I hope you all have a safe week. This is Lakshmi Chella, thanking you again. Regards. Oh, there's a question. Oh my God. Okay. There are 5 more questions. We are already at 120. But for the ones that are left, I'll go ahead and answer these questions because I hate not answering. We've answered 51 questions today, 51. So I filed a petition for my spouse and stepdaughter in 2016. They're now in the US. I filed an I-751A in August. Can my stepdaughter file for citizenship after 3 years of green card? Because she's not my biological daughter. Is there any difference between biological children or not? My daughter is 20 years at this time. Well, I know your wife can file for it. And there is a very complex derivative citizenship regulation, aside from filing for an N400. And it's the most wackiest formula you have to go through. But Anil, I know you emailed me. If you could send me a reminder, I can take a look to see if, and you said she's 20 at this time. Tell me when she turns 21 via email, and I'll see if she would be eligible for the derivative, in which case, the mere fact that your wife has filed, she would get it automatically. If the PD is current, the I-140 is approved. If the priority date is current and my I-140 is approved from my previous employer, do I need to join my old employer immediately or join them at a future date after the petition is approved? Yes, because green cards are for prospective employment, not current employment. It's prospective in the future. So as long as there is that you are going to join that employer, then yes, you can file the adjustment based on prospective employment. I'm on an EB1 in the US for priority date of 2019. Any projection when this will become current and when October visa bulletin will come in? I think EB1 is the one category that I think will be current. I don't know when the visa bulletin is going to come out, but what I would do is start putting your documentation together so you can get it filed. It is very important when the visa bulletin has an instance like this. It's really important that you not only file it within that 1 month, but you get it filed by someone who's competent in it. Because what happens is, if it gets rejected for any reason, there is something you didn't do in the filing or the attorney didn't do, then you would have to, you would forego your ability to do this. Now, I'm trying to remember, was it in, gosh, about 15 years ago, the visa bulletin, by a mistake, became open in July. We were filing tons of, we had all the people coming back to the United States so they could file, people who were traveling because it was in the summer. It was chaotic. I gave my clients a cutoff date of a week before. I think it was a week, 10 days before the end of July. Because I said, if something happens to the Postal Service and there's some issue, what will happen to the filing? So I would say all but 3. And they were struggling. And I told them, if something should happen, God forbid, I can't be responsible for a natural disaster that occurs and your petition is not delivered via FedEx. Guess what? There was a tornado and it hit Kentucky, I believe. And so the petitions were rerouted. They didn't make it within the month of July. And I had been saying that all along. And we were able to subsequently fight and get them accepted because it was pursuant to a national disaster. But who wants to go through that stress? Do you want to go? It took about 6 months before we were able to get it resolved. And that was with a friendly USCIS. Can you imagine what this USCIS would do? So once the visa bulletin becomes current, make sure your ducks are in a row and make sure your adjustment is put together correctly, so you have no, it's not rejected. Your webinar is so helpful. Thank you very much. Appreciate you and your team's effort and time. You are welcome. And if you like it, again, please email us and give us permission to show it on social media, just so people know that, you know, we are doing, the webinar is helpful. And if there's some questions you wanted to ask but could not ask, email us at info@cellolaw.com. It is almost an hour and a half. My throat. I think I need some water. But I loved connecting with you. I mean, I mean, I love what I do. And I love meeting all my clients from all over the world and their great stories and fulfilling the continuation of the American dream. And so thank you again for being so giving of your time. And I look forward to seeing you next week. And this time I'm really saying goodbye, not just faking it. It's goodbye. And there are more questions, but I tell you what, email me so I can let everybody go back to getting back to work at info@cellolaw.com. If, you know, because I haven't been able to, because every time I answer all the questions, there's 2 more that peep up. Well, good. It's just, these are all thank you notes. Well, I am glad. And I hope you all have a spectacular day. And like I said, if you have a follow-up email or follow-up question, just please go ahead and email me, and we'll be happy to answer it. My team is just as dedicated as I am, so I'm lucky that way. Bye. Goodbye. Take care.